everyone, and welcome to this bite-sized webinar specially designed for the independent school sector on independent schools in the UK, legal risks and best practice. This webinar is part of our Independent Schools webinar series, which will cover a host of legal topics impacting the sector. If this is your first time joining us, links to our previous webinars will be included in an email to you after the session. You can watch it back if you wish.
Today's session is being recorded, and a copy of the recording along with the slides will be sent to you by email after the session. If you've got any questions about anything we're covering in the content today, then please use the Q&A function and one of our team will get back to you personally after the session.
So firstly, a little bit about Louisa and I. So you can pronounce my name, it's Amanda Timcke. I'm a solicitor with broad experience in commercial real estate, but I have a specialist interest in education, having led a cross-discipline education team at another firm prior to joining the fabulous Birketts. I have also been a governor and a trustee of a primary academy trust. So I'm thereby specialising very much in estate management issues, revenue and capital investment projects, particularly with further education, local authorities and, of course, independent schools.
I'm Louisa Saunders. I'm a legal director and I lead our charities, not-for-profit and heritage real estate team here at Birketts. What's so special about our team is that we get to advise organisations which are all about purpose and impact, which is incredibly rewarding. My practice brings together 20 years of experience as a commercial real estate lawyer, like Amanda, but I have a specialist focus on regulatory and governance advice, so I can help these organisations to achieve their property goals. My clients include a diverse range of organisations, so ranging from small local museums to a heritage site in London with an investment property portfolio, and through to major charities with a national retail and operational footprint. And of course, this includes independent schools, many of which are registered charities and many of which are also custodians of historic buildings.
Hopefully that gives you a good insight as to why we are leading on this webinar for you today. Independent schools operate in a unique landscape, and getting the property aspects right is essential, not only for safeguarding your estate, but also for enhancing the experience of pupils, staff and the wider school community. Independent schools face financial pressures from fluctuating enrolments, rising costs and the need to remain competitive. Ageing historic buildings require maintenance, modernisation and fitness for purpose to support educational needs. Sophisticated estate planning balances legal, financial and operational needs for sustainable school management. And increasing demands from independent schools inspectorates, Charity Commission and the DfE require schools to maintain compliance and governance standards. Board composition is important for scrutiny and oversight, and many solicitors at Birketts actually sit on boards for independent schools. Louisa, did you want to mention about the trends for independent schools property transactions?
Yes, sure. So as you'll all be very aware, at the moment, a lot of independent schools are really concerned to try to optimise their estate to drive revenue growth, to lead to more income. And so we're seeing a lot of inquiries about sales of surplus property assets to bring in capital, along with looking at sharing facilities with other organisations to bring in hiring or lease income. We're also finding there's a growth in early years provision, and that can involve doing leasing arrangements with nurseries. And against this backdrop, we're also looking at energy efficiency and looking at sustainability and new ways of achieving that. So things like heat pumps, solar, and also independent schools increasingly looking to achieve their ESG objectives. And also there's a big increase in mergers and acquisitions of independent schools to try and remain competitive in what is a challenging market, and that can involve the consolidation of estates together.
Just when you're describing that, I can see that there's so many other solicitors and teams in our firm that are involved in these sorts of transactions, just keeping things moving forward. That's brilliant. From a property and transactional perspective, as we are the experts in this sector today, we've come across a number of different land ownership structures, which is worth pointing at to start with, because independent schools often use trusts, foundations, and there's sometimes the complication of diocese-owned models. So there are particular implications on estate decisions, especially where you're repurposing or the amalgamations you mentioned, or where even closures are considered. So the correct stakeholders must always be engaged.
And I'm just going to talk a little bit about charities. For those of you who are registered charities, many independent schools are, but not all. So whenever independent schools who are registered charities are dealing with land, there is a whole layer of additional regulation to deal with. So not only are you looking at commercial and operational decisions, but you're also looking at charity decisions. And those are governed by charity law and also statute with the Charities Act 2011. And it's essential to get these right because obviously charities are regulated by the Charity Commission, and independent schools will be operating in a high scrutiny environment. So I'm just going to touch on two main things around charity law compliance today. So first of all, trustee duties in the context of land and buildings. So trustees have a duty to only act in the best interests of the charity. And in fact, being a charity means that trustees can only act in accordance with the powers that they are given to fulfil the purposes of that charity. So what that means in terms of estates and property is that everything has to come back to being within the charity's purposes. And there must be a clear line of decision making which can justify that anything that's being decided is being done to advance the school's charitable purposes, which will be the provision of education, of course. Trading is something that occasionally comes into the picture where independent schools are looking to secure income from perhaps partnerships with developers or other third parties. Now, generally speaking, primary purpose trading, so that's trading in direct advancement of the charity's educational purposes, is obviously permitted. So you'll be charging fees for the provision of education. This can be tricky when you're looking at perhaps land development arrangements where perhaps you might be partnering with a developer. In those sorts of instances, that can be classed as non-primary purpose trading, and there are quite strict limits on the amount of non-primary purpose trading a charity can do. So really, we would advise that wherever that's happening, specialist tax advice will be needed. And sometimes a trading subsidiary will need to be set up to manage that risk, and it will also help to mitigate any adverse tax consequences. Decision making, I talked a little bit about. So any decision making must be properly documented, and it should also ensure that conflicts of interest are properly dealt with. Now, these occur quite frequently in school matters, in school governance. You may have trustees who are parents or former pupils, or possibly even connected to contractors or developers who you're working with. So you must have a very clear policy on managing conflicts, and in some cases, an authorisation from the Charity Commission will be required. And you should just be aware that even a perceived conflict of interest, so even where there isn't really one, but if people think there may be a conflict of interest, that can actually impact quite severely on the school's reputation. The other thing I just want to talk about, I'll try and make it brief because I can talk a lot on this subject.
It's all really interesting, Louisa, don't worry.
Is the charity law controls on land disposals. So charities are subject to a statutory framework around disposals of land. And it can be quite useful to understand the historic context for that and why it's the case. So it goes back to times when land had a very central importance as the way of anybody securing an income. So, and this was particularly for the case with charities as well. So they would be given a piece of land, and that was the way they achieved their income. And originally, the position was that actually the consent of Parliament was needed to make any disposals of land for that reason, that it was seen as a very key asset for the charity, and that any disposals of that should be very tightly controlled. Obviously, the law doesn't always quite keep pace with modern society, but the framework has moved on since then, but is similar. So the default position under charity law is that any disposal of charity land will require an order of the court or of the Charity Commission. However, fortunately, we don't tend to have to do that, because the Charities Act sets out a framework which will enable most charity land disposals to happen without consent. So in the case of short-term leases, for example, so that's under 7 years, provided the charity is obtaining the best rent reasonably obtainable, and that's backed up by the advice of someone that has suitable qualifications, then the charity can proceed and no consent is required. Longer term disposals, so that's grants of leases in excess of 7 years or freehold sales, those are also generally permitted without consent. However, the charity must still obtain the best terms reasonably obtainable, and its terms, not just price. And this must be backed up by a formal written report, which is called a designated advisor's report. And there's actually a separate statutory instrument which sets out what the content of that report should be. This all sounds quite inflexible, but just bear in mind that the purpose of these requirements is very much to protect charitable assets. It is there to give trustees a backstop and to help them avoid entering into unwise decisions. So it ensures they understand the value of the property that they're disposing of. It ensures they think about why they're doing it and whether this is in the school's best interests. So I would encourage you to see the requirement for a designated advisor's report as a positive thing, and supporting your decision of what you're trying to do in the charity's best interests, and try and engage with the surveyor as early as you can in the process to get the best possible benefit from the advice that you're receiving. There are a few exceptions to this procedure which I need to mention. So just be aware that whenever there is a transaction with a connected party, so still talking about charity transactions here, that will always require a charity commission order. So that's where you're disposing to a connected party. And that is because of what I was saying about the potential for a perceived conflict of interest. Even if there isn't an actual conflict, it just doesn't look right. And so the law steps in and requires that that is sanctioned by a charity commission order. So what that means is that you really just need to identify any connections as early as possible so that your solicitors can make sure that any required consents are obtained and that it doesn't hold up your transaction. Land held on special trust, that quite often crops up for independent schools. So we're talking there about land which might be part of your original endowment and may be held on special trust such that it must be used only for the purposes of providing an education for pupils on that site. Can be quite complicated, and your lawyers can advise on whether land falls into that category. But the key thing to be aware of is that with that sort of land, there is an additional layer of regulation in that quite often public notice needs to be given, and that will be for 2 months. It doesn't mean that anyone has a right to buy the land or that they can stop you proceeding, but it's all about decision making and showing that you're involving your stakeholders. Again, 2 months is quite a long time, so it does have potential to delay your transaction, so it's best to try and flush out some of these issues as early as possible. And finally, just in terms of situations where these requirements don't apply, there is an exemption. Probably the most relevant one for you is the charity to charity exemptions. So perhaps if you're doing a merger with another school and land is going from one charity to another, where the objects of both are aligned, then there is no requirement to go through all of these procedures, because effectively the land is still being held on the trusts that it started with. There's also a similar regime for mortgages of charity land, which I won't talk too much about, but again, just be aware that there are Charities Act regulation to go through whenever you're dealing with mortgages.
That's really helpful, Louisa, because there are things there that you wouldn't automatically think about as important for independent schools. And just as you're talking, I'm thinking of a matter where a very historic educational private school came to us to say, actually, we've got a falling role, we haven't got enough people coming in, we're looking to close, but can we let the premises for an income to another organisation? And when we looked at their trust scheme it was clear that they could not do what they wanted to do. They would need to go back and get Charity Commission changing their articles. Is it objects and articles? See,
yes.
It's the terminology that confuses us all. And it was really, really difficult because they were really financially up against it, and obviously had students to rehome as well, and all of those timescales that go into an education instruction is very, very critical. But I think we're probably actually moving on to the next slide, which has some generic, more estate management side of things. So in this, if we could just go back one slide, actually, I think. Thank you. We should be mindful. We're talking about risk registers and consulting with people and ensuring everything is correct, but we also need to make sure that we have the correct data protection, secure access, visitor management, CCTV, and really ensuring that you have governors who hold accountability for the conflict register that you've just mentioned, which it needs to be kept up to date, definitely. Health and safety records, asbestos, just ensuring really that you are obtaining the correct advice from a variety of professionals, HR professionals, data protection, regulatory, commercial and governance on a regular basis, and that you are following those risk registers through, and not just every quarter or every term or every year, some people do, but on a more regular basis, aligned with your plans for your 3 years, your 5-year plans, and making sure that's all in place. And then some of the other practical points that we've come across perhaps can be avoided. We've also, you've been talking about third-party access, need to make sure that all of those documents are clear, so responsibilities are properly in line. But yeah, issues in managing education estates. Louise, I think you've got some more examples, haven't you, that are quite current?
Yes, I'm just going to talk a little bit about regulatory compliance in terms of energy efficiency certificates and the drive to net zero, which is something I'm quite interested in, and can be quite challenging in the context of perhaps estates with certainly older buildings and some with heritage buildings. So EPCs, energy performance certificates, they've been in for a while, and you're probably quite familiar with those.
You may have DECs because it's a display.
Yes.
For public buildings.
Yes. What you might be slightly less clear on is the requirement when it comes to dealing with disposals of land. So it's a legal requirement on any sale or lease of commercial property, which would likely be the case for your estates, that you must provide an EPC with a minimum rating of an E, which is a relatively low bar. Currently, it's relatively easy to achieve. From the 1st of April 2023, it's actually become unlawful to continue to let property with a rating below an E. And that's the case even if the lease was actually granted before the regulations came in. So it's important to check that you've got those certificates in place.
I've had some issues with that when it comes to funding arrangements, because people weren't, aware of it, and the building wasn't exempt or on the exemption register.
Yeah. And sometimes it can be quite easy just to do some works that nudge that rating up to an E. But you should be aware that it's not likely to remain E for very much longer. There has been various consultation going on about bringing the standard up to C, and that's likely to come in the next few years. And I think we're going to then start to see this whole regulation of energy inefficient buildings play out. Currently, people don't tend to get too excited about an EPC. We're usually asked to provide one when we're dealing with a sale of a property, for example. But generally they will pass because of the standard being an E. When the standard goes up to C, I think what we're going to see is more use of the PRS exemptions register. So what you are supposed to do is, where you cannot comply with your currently E rating, soon to be C rating, you need to be claiming a specified exemption, which is actually registered on this exemptions register. And if you don't do that, there can be fines and penalties, which can, I think, range up to about 150,000, which is probably the absolute worst case scenario, but it's something that's going to become much more topical in the years ahead. So we'd encourage you to keep carrying out audits of your estate, make sure you're aware of where you are with energy efficiency levels. Where you find that older buildings are not going to reach the required state rating, then you need to be finding out which of the various exemptions they fall into, and you need to be logging those on the exemptions register. I won't go into all the exemptions, but
take legal advice.
Yes, there are some that are to do with payback. So, for example, where the amount it would cost you to spend on upgrading to get to C, where that doesn't pay back over the lifetime of the lease, it's actually possible to then secure an exemption. So you just need to look into that and understand where you stand on all of that. And of course, all of this is going to help you with making your estate more sustainable and helping you meet your ESG objectives. In terms of heritage constraints, so clearly any schools that hold heritage buildings, as you'll be aware, any sort of development is more tightly controlled. You may be in a conservation area, or even in an area where there's a particular sensitive landscape. Even small things like upgrading windows and changing accessibility requirements can trigger the requirement for heritage to be considered as part of any planning applications. So what we would suggest is that you engage early with heritage professionals who can help you plan and mitigate any risks and make sure that you have plans in place for how to deal with these issues. Climate change and environmental strategies and the drive to net zero. This is becoming more and more topical. At Birketts, we are required to report on our ESG objectives regularly, and independent schools will be no different. You may find that when it comes to funding that you are asked questions about this. And so some of these measures that we're talking about with the EPCs and minimum energy efficiency standard will all help you towards demonstrating what you're doing on that score. It can be tricky, obviously, when you're dealing with things like listed buildings, but having the right heritage consultants and energy advisors can help you make sure that you have a plan in place.
It's also important because you can then obviously have your overheads that you're trying to reduce and encourage your income generation through often climate resilient methods of power, etc. That's great. Well, if we just go to this last slide here, I think really from a practical perspective, we've talked about the sorts of things you should be looking for. And ultimately, these are all to drive the income against your outgoings, to encourage and support curriculum delivery effectively and attractively, because we will want to entice students to the school, because it is a very competitive environment, and ensuring as well that any new projects are dealt with in a good risk management method. Infrastructure is built in a resilient and environmentally friendly way for first class learning environments. So there's that, it's not an easy job to run an independent school, and we understand the risks and the practical issues that you face, as well as the legal issues. Again, with property transactions specific to independent schools, Louisa has touched on a number of these, and the slide really does highlight some of the nuances and red flag things that need to be mindful of. And really, again, aligning with strategic planning and having from the outset the proper stakeholders involved and the proper decision making, and legal and estates surveyors employed is critical, because we have shown really in this discussion that the various nuances for even just land ownership, which might not be aware of, and the terminologies used, which might catch you out because you're not thinking that an independent school, for example, has charity law implications. So if we turn briefly to the case studies.
Yeah, so we just wanted to talk you through a couple of case studies, which illustrate some of the themes we've been talking about. So first one is around heritage constraints. So we were advising a long-established school who wanted to replace their 1970s science block. We've probably all had our science lessons in something like that, with a new up-to-date STEM centre. But the school was on a heritage site, and there were issues raised with the design, and the way the school overcame those was by engaging an architect to draw up a different plan, which addressed the various heritage concerns with the building, and also dealt with mitigation of ecological concerns on site. And in that way, they were able to proceed with the new development in a cost-effective way with a minimum of delays. In relation to the charity law issues that I have been describing, we have also been advising a school who is trying to secure some capital value from a piece of unutilised playing field land, and they were looking at doing a deal with a developer on that. So we talked them through the issues and the requirement to obtain a designated advisor's report right at the start of the process. And as a result of that, they have engaged a specialist surveyor. We do keep a register of surveyors who are very experienced in providing these reports, because it can be quite tricky to source the right type of report sometimes. And as a result of that, they were able to negotiate better terms for the deal, and they also included overage, which is essentially the right to participate in the profits of a successful development, and that is all part of it, making sure that the school is achieving best value from their land. So that means that if anybody looks at the sale in the future and queries why a certain value was achieved, the governors are able to say, well, we took advice, we followed the professional advice, and we did the best that we could, and really that is what the duty of the governors is to make sure that they commission the right advice, so that they can rely on it.
And interestingly, they obviously got a better deal by engaging the right advisors and experts at the outset. fantastic. Mine aren't quite as exciting. Again, more of a estate management perspective, but it's these registers, and obviously with things like RAC that came up recently, we should not forget asbestos. And I had a situation where one part of a building in an independent school had undocumented asbestos because the note there says incomplete registers, but it was just one of those things that a building being brought back into life and the assessment had been missed. So we had to then go and commission full surveys, correct the compliance gaps, and obviously there were issues then with the contractors that had been brought in to do some works on that building, and really it was a situation where they needed to learn from that, but the costs went up because of the unanticipated asbestos there, which the school had not budgeted for. So again, check the registers, check every inch of your estates, whether or not they're actually open to the staff or the students or the public. And another one which is a bit more interesting because it relates to digital infrastructure, and we're all about the digitalness today. Digitalness, that's not a phrase. But things we don't think about sometimes is filtering and monitoring what is actually being produced through the Wi-Fi systems, and the schools completed a digital audit. They had a specialist in, and it was quite clear that there was a risk to safeguarding because of the flow of information. So they upgraded the systems and added digital risks to its estate risk register. And I must admit, I've not seen that very often, digital risks registers. So that's a tongue twister. So that was quite interesting. Thank you. If we go to the last one, oh no, we're right at the end. So by way of summary, really need compliance status of all the buildings and long-term estates master plans, including, your wishes of what you could do, as well as your absolutes, so that you can encourage the financial sustainability and the legal compliance, which has cost implications for the future of your educational establishments. And as hopefully my digital note before reinforces, safeguarding needs to be integrated into the estate and not considered as a separate matter. It's pervasive. So I think that probably covers the last of our notes. Any other final thoughts? Or thank you all for joining us today for the webinar, Property Elements of Independent Schools. We've covered a wide range of considerations from estate management and compliance obligations to strategic planning that supports both educational delivery and long-term relationships and sustainability. We hope today's session has given you practical insights, clarified some of the more complex issues, especially with Louisa, and highlighted opportunities to strengthen your school's approach to property management. If you have any follow-up questions, or if you'd like to explore specific issues in more detail, please feel free to reach out to one of us.
And as mentioned earlier, a recording along with the slides will be shared with you by email. So if you do have any questions on anything we've touched on in this session, then please feel free to get in touch, and a member of the team will send your inquiry over to us. So thank you very much for your time today and for attending our webinar, and we hope to see you soon. Thank you.
Bye-bye.